constituents or for those who are Knox County. There are some issues that are bigger than a conflict. If they're revealed, everybody knows about it and says, I'm voting this way for my constituency, for my conscience, and that is bigger than a conflict of interest that I have, because you are going to disenfranchise the voters for that. Let's take the issue here that comes up about reapportionment, one I want to talk about next. Can anybody here say that a commissioner that would vote for the district plans, for yours, for the school boards, or whatever, claim that you don't have a personal interest in that vote? I dare say that most commissioners, you would have a hard time defending a person that you do not have some interest in where those district lines are drawn. If you read this correctly, most everybody would have to recuse himself from the vote, which means you can never vote in a reapportionment plan because none of you could hardly deny that you had a interest in whether we're in the same district or different district or whether somebody else is in or not. It's a very important issue. Everybody would have a conflict, but if you had to force yourself to recuse yourself, you have a hard time getting there for that. Let me address the last one, and Commissioner Briggs brought it up very early today, and that is the reducing the size of the commission, at least those by districts, to 9. Now, that parallels the number that's on the school board, and I see the wisdom when they say, well, we have the same number, and they say, wouldn't it be nice if those two districts would line up? There's some reasonableness in that, okay? There is. I mentioned before that I drafted the reapportionment plans for this commission 3 successive censuses. I don't plan to do it again, but it is not easy. There are constitutional requirements, and I've always advised my colleagues when they say, I don't like the district, Commissioner Leuthold, that you're purporting, and I said, well, these guidelines got to be followed. If you break them, in 1 year, both the General Assembly and the House and the Senate, they thought they could do this. Both times courts overturned them. Ours in Knox County would never overturn because Iowa insisted that constitutional provisions must be followed and adhered to strictly, 100%. If you got one person that's greater than that number, it's unconstitutional. The other one is clearly political considerations. And politics invade politics. You don't take politics out of politics. Now, if you must align these with the school board, you introduce further complications. Why there's some wisdom to that, there's some logic to that. I would think that the political difficulty of getting them. 1 year, the school board, and I think it was 1990 census, they gave one, they gave the list to the law director, and it happened to be in the law director's office, Richard Beeler. And he said, Commissioner Leuthold, the school board just turned theirs in. They never asked anybody for help. Take a look at, since you drafted those for the county commission, could you give your thing? And I said, well, school board can draft their own. But I took a look at it and said, well, it's unconstitutional. I said, because they got districts that are split. It's like putting a precinct in East Knox County and West Knox County and putting the same district. You can't do it. And I said, well, I can tell the school board that what they're proposing is in error, or I could attempt to try to follow their logic and go through that. And I worked on that. And I did it very quickly because I knew how to move those things around. Unless you have experience, you just couldn't do it. Anymore, you could do heart surgery. Dr. Briggs could do heart surgery. We would take many years if we could possibly get there to do it. Because he has experience, he can do it, know how to do it. So I knew how to do it. And it came to the conclusion at that time that there was no combination of precincts anywhere in Knox County that met the constitutional requirement. None. Zero. The only way to make that work was to move some precinct lines. And then that had to be done thinking how you would do it. There's a domino effect. It's not easy. Now, if you're trying to match those two up, the other thing that you have under that is that this charter requires you to do this prior to the 2010. You're doing that on the census of 2000. Okay? That's what we're operating now, the census 2000, which we would have to reapportion. Then it directs you that because federal law requires after you do the 2010 census, before the next election, which would be 2012, not for county commission as they state, that wouldn't be until 2014 or 2016 as provided in here, but the school board, because they have staggered terms, would be in 2012, so you would have to do that. It would be possible that several county commissioners who would be serving 6 years terms under this provision would not be living in their district for 4 years because the districts would be changed. Now, when you stagger the terms, that's possible for 2 years by definition. School board members right now could be out there. Commission can never be out because they were all elected at the same time. You're either in or you're out. Can this be handled? Yes, it is done before. State Senate might have that provision at time that you'd be in when they reapportion, and you might be out of your district for 2 years of that term. This would, back on 6 years, you could have some commissioners out of their district for a period of time. Let me add something else that came up in the debate here about when the charter can be changed. I may be wrong, but I think that the Citizens Initiative for term limits was passed in November. Is that correct? But it was passed. There was citizen initiative to have that. So, you know, I think it can be done then. The Supreme Court upheld that provision for that. I would think that as being a legislator for a long term, the ability to debate is always good. I respect this commission. I respect these petitioners. I've known them for a long time and respect them. There ought to be some ways of getting some things here, studying them, see if we can clarify some things. So if we can stay out of court to determine what did we pass. The term limits is one of them. It was passed. The voters presumably thought that they affected many offices, but the Supreme Court finally said that state law says you cannot do it for school board. You cannot do it for anybody that's related to the judicial system. That's why the clerks are out and the Attorney General is out for that. But still, on the books, we said everybody, but we didn't get everybody. So state law does come into play. I, like some of you, do not know when state law comes into play and when it does not come into play. And those important issues. And I appreciate the law department, Mary Ann and Stackhouse, John Owens, who have always done their level best to give opinions, and all the predecessors for that. The word of the wise is, and I did that with fellow commissioners, when the law department opines, you ought to listen. Sometimes I had maybe a different political agenda than maybe what they were opining, and I says, I want you to research it more. I want you to research it more. I want you to study it more, because you're not giving the answer that I want. An independent law director, if he's willing to tell me that I'm wrong and they're right, they're willing to tell anybody the same thing, and that's all I want, is them to give that same advice to everybody and not be beholden to anybody. And so an independent law director, to me, is very important. We're doing that for an inspector general, the same concept. That law director advises all departments. We ought to make them as independent as possible so they give the strict legal advice. Whether you like it or whether you don't like it, it ought to be the correct. And I thank you kindly for listening to me and granting me more than fine